If your brand belongs in the heart of the yachting world, this is where it happens. Yachting International Radio reaches over 1 million yachting professionals and enthusiasts every month, with 77 million impressions, 220,000 social followers, and 74,000 podcast subscribers. Our hosts are insiders, crew, captains, CEOs, trusted voices shaping the industry. This is targeted, high-impact advertising in a luxury niche. Visit yachtinginternationalradio.com/advertise. Your audience is already listening.
Cristina, welcome to Yachting USA, and thank you for the hospitality. It's good to be in your offices here this morning.
Thank you, yes.
So this is interesting because we're here to talk about a potential or real class action lawsuit against Safe Harbor Marinas.
That's right.
Okay, and of course, you're here in the heart of the yachting industry. We talk about Fort Lauderdale being the yachting capital of the world, and Safe Harbor has a very strong footprint, not just here, but throughout the United States, and they are growing their footprint. I was in an off-the-record conversation with Safe Harbor Marinas back in May, and was told that they're looking to double their footprint over the next 5 years, with the increase in market being in the European market space.
That's impressive.
They are an impressive company. They're growth oriented. They have just announced the acquisition or the partnership with Monaco Marine, which is a well-known company in the south of France. So Safe Harbor is definitely, they're a presence in our industry. They're a force to be reckoned with. I think they're necessary for our industry and the services they provide and the infrastructure that is part of their program. But at the same time, I continue to ask the question on this program, you've heard it before, are all these M&As healthy for our industry? You know, is this good for our industry to have a very limited number of entities with such a significant market share? And Safe Harbor and One Water and MarineMax and others kind of fall into that group. And so this conversation is not new. And it's something that I do want to continue, and I'm pleased and honored to be able to be here with you today.
Thank you. Well, you raise a very good question, because obviously the consumer focus is what I'm looking at things through, and we want to make sure that the consumer always has choices. When a consumer doesn't have choices as to where to go for whatever the service or the product is, that's when problems can arise. You can get deceptive practices, you can get coercive policies. Things are done in a different way because there's not a risk that the consumer might go across the street or to another vendor. So that's why we have class action lawsuits. That's why there's consumer protection laws. And that's obviously my focus.
Perfect. So now you're a partner with Kelley and Uustal.
That's right.
And Kelley and Uustal is a firm that's not just located here in Fort Lauderdale. You've got a couple other offices around the country.
We actually litigate nationally all over the country.
Okay.
So we have a lot of partnerships with other local firms in various jurisdictions.
Right.
We litigate a number of cases in jurisdictions like Las Vegas, Nevada, Chicago. I just had a case in Illinois myself. We have cases all over the country, Boston. I mean, seriously, we litigate wherever we need to go. I had a class action that I filed in Georgia. So, and historically, myself, in my 10 years here at Kelley Uustal, I've litigated all over the country as well.
Perfect. And to be clear, Cristina, today, we're not litigating here on microphone. We're here to inform the public about what this lawsuit alleges and really how class action lawsuits work.
Sure. Absolutely, that sounds fair.
Perfect, good. A little bit about your background in all this. I'd love to hear it. I'm sure that people that are following our show would love to hear this.
Of course. I've been litigating for about 30 years. I've been here at Kelley Uustal 10 years, like I said. I have a focus on commercial cases, complex commercial cases, and class actions. I've done some key TAM work, which is when the government has been overcharged or deceived into paying billing practices. I've done some of those cases. But primarily, it is complex litigation, construction, breach of contract, any kind of business tort. And I am board certified here in Florida in business litigation.
Okay.
I've had that certification for over 10 years as well. So I really enjoy litigating. I like being in the courtroom. I like to take on big corporations when necessary. And I like representing consumers who a lot of times don't have by themselves enough power, but together they can yield a bigger weapon. So that's kind of been my focus and my passion.
What motivated that passion? Where did that come from?
I don't know. I started as a defense lawyer, and I represented a lot of really big corporations in my first 10 years of practice. And I didn't like that side of things. And I felt like you need to have really strong litigators, especially women litigators, that can bring another aspect or another view to the plaintiff side of fighting a big corporation or whoever you're up against. And so I kind of got involved from that point, and then I kind of got to know John Uustal and decided that was going to be a good mix for us. So that's how I kind of went into that area.
That's fascinating. That's cool. I just think about like Aaron Brockovich and things like that. And,
Yes.
You hear these stories and you see the results and you think, okay, you know, if not for,
It's a great example.
you know, brave people like that to really take on, you know, the big machine.
Yeah, no
you know.
intimidation. You know, you have to just take it one step at a time. You got to review every document. You got to talk to every witness. So it's hard work. It's tedious work. Fortunately, God blessed me with a very good memory.
All right.
So I can really, you know, kind of absorb and keep it all in here. And I do that in every case.
We all have our gifts.
That's right.
So before we get into the specifics of the Safe Harbor Marinas, talk to us a little bit about class action lawsuits in general. Why would we do it? What's the upside? What are the challenges?
Yeah, I think the upside, as I indicated, is it's a way to maybe cases have a small damage involved, or it's a case where just one person complaining about something might not get as much attention. And when you group everybody together for that same practice or that same method of doing business, and you can attack that or challenge that as a class, you get the kind of power you need. You can afford the litigation. Litigation is very expensive.
Yeah.
And, you know, for an individual to afford to hire a law firm to do a case is very difficult. And so when you have a class action system in place, then that cost and that can be shared amongst the entire case, as well as the power that you can pack a punch going forward. The challenges, obviously, from a legal standpoint, I think it's more and more difficult in the courts and the legal landscape that we're dealing with to get classes certified. The other thing that's happened is big corporations have become more and more likely to have an arbitration clause in their contracts, and they've gotten better at writing their arbitration clauses. And so it's harder and harder to have class actions. There's also something called a class action waiver. I've been a big proponent of limiting the ability to use a class action waiver in consumer contracts. Because, you know, if every cell phone provider puts in a class action waiver, then there's no choice for the consumer. There's only a handful and they all have it. So that means that a consumer can never bring a class action. So if a cell phone provider or a company has a thing that only costs or charges the customer some deceptive charge of $100, you know, what individual customer is going to take that on?
Right.
So class action waivers in the consumer environment really should not be allowed. But for currently, we're dealing with that. I'm battling it in the courtroom whenever I can. But all of these things have made it more and more challenging to bring class actions and to successfully do that. But when you can, it really does allow for a systematic change in the marketplace, because a court will say that practice was improper, and that practice then gives relief to a whole group of people, and they can change it. Just to give you a couple of examples, one of the industries that I took on for about 10 years was bank overdraft charges. And so we were able to successfully, some were certified and some were settled, but we were able to do practice changes where, you know, very large bank agreed for a period of at least 5 years to forego this certain kind of, it's called a secondary overdraft charge, where the overdraft stays in the bank, the account stays overdrafted for more than 5 days. They would give you another overdraft charge.
It accumulates.
Yes, and so that we got them to stop that, and we have since then, through other efforts, they have abandoned that. And banks, because they were sued by us and other law firms on this, they have now changed their overdraft policies in a lot of ways, and even some banks are using that as marketing. Hey, we don't charge overdraft fees.
There you go.
So it really changed a lot of consumer practices. So class actions can work.
In the mindset of lawsuits and class action lawsuits and, you know, intent and purpose, it's safe to say you're not going after businesses to take out or destroy or damage the business per se.
No, not at all.
You're looking at practices that are perceived, real or not unreal, to be determined, to be either unfair or disproportionate or just
deceptive,
whatever,
misleading. It could be any
right.
of those, correct.
So you're really looking to change the demographic of the contract, change the experience that the consumer has by calling out perceived bad behavior and
Right.
trying to affect that kind of change.
Yeah, and most states have protective laws, usually an Unfair or Deceptive Trade Practice Act. Florida has one, South Carolina, where we are, has one. Most states have them, and they're in place for that purpose. There are consumer protection laws. And so when we couple that with the class action technique or method, you can really accomplish great change, and you can do things for the consumer that you might not be able to do one-on-one. In South Carolina, however, that act is an individual act, so the individual must bring that. But Rhode Island, Florida, there's lots of states where they encourage it to be brought as a class and to be used, that statute to be used as a class.
Okay.
So it can happen in different ways. But yeah, the focus is not to hurt the defendant financially to the point where they can't operate anymore. To the opposite, it's to, we know that they have a lot of business, they have a lot of consumers and customers, and we want them to realize that this is happening. And if it's happening intentionally, we want to force them to make changes to the way they're doing things.
Perfect. So let's dive in a little bit. What triggered this particular case?
This particular case was triggered by a contact that was made to me by a vessel owner it's actually a Fort Lauderdale, Miami vessel. Charter business, was returning from New York to Florida after some charter business and broke down near South Carolina, near Charleston, and was brought into that marina, Safe Harbor Marina there. And the story that transpired from those transactions led us to the conclusion that the policies and practices that basically they were following was coming from the home office. And this is all in our complaint, in our lawsuit, that this was, hey, this is what corporate says, this is our corporate policy. And it involved a lot of surprise charges that weren't told about, surcharges on work that was done by other contractors, not even hired or managed or guaranteed or supervised by Safe Harbor, yet they wanted to add 10% to whatever those outside businesses were that came on to work on the boat. And, our client was just outraged and complained. And, still these surcharges showed up on the final bill. And it was like, hey, well, you might dispute them, but you have to pay them if you want your boat back. Mm-hmm. So it just became a very, distasteful, problematic, and unfair situation to the point where he felt very deceived. And the company, it's a charter company, their representatives contacted us. And then we began talking to other clients, the potential clients that we knew, that we thought could be good witnesses, and people in the industry, boat repair shops in the vicinity, to find out whether they had any experience with being surcharged. And we've spoken to a lot of witnesses, we've done a lot of investigating, and we have learned that this is not an isolated situation. This is very emblematic of what happens with customers around the country that use Safe Harbor Marinas. And I've received, I've mentioned already that we've spoken to not only boat vessel owners, but people that work in the industry from all types.
Absolutely. And that's not horribly surprising. And it probably goes beyond Safe Harbor Marinas. There are other shipyards that have similar practices that I'm aware of. And whether or not those are legitimate or good practices or not, to be determined. But, we are in an industry right now that is working hard to become more of a professional industry. Good. And you look at companies like Safe Harbor Marinas and others that are now owned by large corporations and have gone through their own M&A and are, like you mentioned, this is coming from corporate from above. It's out of our hands kind of thing, which sometimes can be a cop-out, I think. Sometimes I think the individual shipyard managers have some latitude and some ability to, work with their customers, but sometimes it's easier just to say, yeah, can't do it. They
exactly.
say so. Right.
Exactly. And you wonder, whether a lot of these procedures and policies, have existed for a long time. Mm-hmm. They're newly instituted after they were acquired by Safe Harbor because they have grown so quickly.
Yeah.
But nonetheless, now that it's all part of one organization, they're responsible for what happens at each location.
138 marinas.
That's a lot.
In 24 states?
Correct.
Right, so.
Yes. And, like I indicated to you, some of the people that we've talked to vessel owners in Rhode Island, quite a few from various of the Safe Harbor Marina locations, Massachusetts, Detroit, Florida, West Palm, Fort Lauderdale. we've talked to a lot of vessel owners who have reported very similar situations where, there were surprise charges, where I think I had one customer who was charged to prepare an invoice. And that was after the fact. They were told, oh, by the way, you owe us $400 for preparing an invoice. So there's a lot of customers that have called us saying, that, they didn't tell me this, and
Right.
I never agreed to this, and then they expect me to pay it. So, it's that kind of deceptive type of practice, lack of communication on the front end, lack of clarity in any of the documentation that's being given up front. These are the things that we are focused on in our lawsuit, is addressing that lack of clarity. And the question is, it's deceptive, it's misleading. Is that intentional? Is it, accidental? Whatever it is, the customer doesn't know what they're getting into, and that's just not right.
Right. Now, in my own prep leading into this conversation, I had a couple off-the-record conversations, and I had a couple captains say, well, buyer beware, they should read their contract before they sign it. And of course, I think that's a legitimate comment, that you are going into any shipyard. You should understand the terms and conditions that apply for that shipyard. But that said, if things like those environmental surcharges are not clearly identified, if a surcharge on third-party materials is not clearly identified, if any of these things that you mentioned are not, will you charge a administrative fee to write an invoice or a proposal? I'm sorry, in my world of business, that falls under your basic G&A overhead costs, and that's normally baked into your basic fees, your hourly fees and basic invoice. So I would find that, from my own personal and professional experience, a little bit offensive maybe. I don't think I'd want to pay for somebody to write the invoice I have to pay.
Right.
So
and
I
that's when you get into...
That's when you start getting that, burn under your saddle.
Yeah, and some of these people already have kind of a dockage agreement with Safe Harbor, that, they live in the area, they have a boat, they want to dock their boat, keep it at the marina. And so they have a contract in place, and then something might happen, something breaks. Oh, well, we have somebody, we can give you an estimate. And okay, that's too much money, I'm not going to do it. Oh, well, you owe me $400. And you're like, well, I don't want to pay that. You're stuck because
Right.
like that particular customer indicated, well, they told me if you don't like it, get your boat out of here.
Right.
And he lives in a location where they're all Safe Harbor Marinas. So, he doesn't really have much of a customer choice. He had to pay it.
Right.
So that's the kind of thing that, we want to dig into, not only here in this South Carolina lawsuit, but, as I talk to more places, there may be the need to expand our litigation to other locations.
Well, it goes into the conversation about the upside or downside of such large expansion of a single entity. So if you're going to own the market, then I think you have to reconsider your business practices to make sure you're being fair to the market. Because
Correct.
if you've taken away the choices to have an alternative location to do business or to park your boat, well, then that should fall into consideration. I would not disagree with that.
But we're early in the case.
Right.
We've just filed the case. We're just getting started, and I'm sure we're going to have lots of new things that we'll learn, things that they'll learn, and that's part of the discovery process.
Yep.
And we'll see where things go.
Okay, that's fair enough. Something you mentioned I thought would be worth putting on the table is this splash for cash thing.
Okay.
On the outside, I know anybody that's not in the industry that's listening to that, you would think, oh my goodness, that is so unethical or wrong or whatever. But
Sure.
Truth be told, if you do the research, you can go back to the 18th century in maritime business where vessels had to pay fully to the shipyard they were in before they were allowed to take their vessel out of the shipyard. And it's there's some obvious, I think, pieces to that. These vessels travel, and
Sure.
they travel outside of our jurisdictions, whether it's state jurisdictions or national jurisdictions. Mm-hmm. And once they're gone, and you can try to put a lien on the vessel. There are certain mechanisms that are available to us in the maritime industry to try to get paid for the work we've done. But the bottom line is we write off a whole lot of expenses because customers disappear. Yeah. So that policy is enforced not just by Safe Harbor Marinas, by a lot of marinas. And I just wanted to kind of advocate a little bit for the maritime industry, marina industry, in saying that while there may be pieces of that are relevant to your case, and if there are, that certainly needs to be adjudicated, however that is going to be.
Certainly.
That is not necessarily unusual aspect of our industry.
Understood.
So I'll be curious to see how, and a lot of people will be curious to see what comes out of that.
Yeah, I mean, look, in every business, there's a risk, and businesses deal with non-payment.
Oh, yeah.
And so any service provider is always going to want to put in some protective provisions, whether it be, deposits, things of that nature. And, the marine industry shouldn't be any different. I understand that here there's some mobility involved, and there may be some geographic reasons why you want to do that. But what you don't want is to have a policy that is in place to protect you, and then instead of it being a shield or a protective device, it becomes an aggressive or a device to use against a customer when there is a dispute about a payment. So, for example, you have a bill for $100,000 and $90,000 of it is undisputed by the customer. You can say to the customer, look, give me the $90,000. I'll do your sea trial, or I'll do what we need to do, and let's continue to discuss this other $10,000. Not, look, you either pay me the $100,000 or we're not doing your sea trial and your boat's not leaving. So there's got to be some, give and take there where the customer isn't just told it's my way or the highway. And even if there's a reasonable dispute over certain charges or practices or a situation that occurred, that you use that policy to just avoid any dispute of any bill that you want to pass by.
Right.
So that's where I think, it's being used, where at least our client, it was used improperly.
And good. I think that conversation is necessary because I would tell you, if you talk to yacht owners and people that have been in this business for a while, most of us have had that experience where you're sitting in your space saying, hey, what do I do? This isn't right, but what choice do I have?
Yes.
Now, you did say in our show prep that you could pay under protest, right?
Correct. Yeah. I mean, I think you don't want to pay and say, I agree. So you just want to make it very clear that I have no choice. You're telling me I must pay these disputed charges. I'm going to pay under protest, and that you document that. And then you make the payment, but you say, I'm reserving all my rights to come back at you, either it's through a legal process or some other process, to get back my funds that I paid you under protest that I don't believe you deserve.
And so for those listening who are sitting here going, well, why this is such a big deal? And, in the context of this lawsuit coming forward, what would trigger something like this? The numbers that you shared with me, and I believe are evident on the documentation you shared with me, is that the initial work order that this client received when he agreed to do this work up in Charleston was $218,000.
Yes, approximately that, yeah.
And for most of us, that's a lot of money.
Yeah, it's a big boat. There was big problems, and they had a lot of work to do, and he knew it was going to be expensive, but not what it ultimately turned out to be.
Right. And in the context of our industry, too, when you say a big boat, it was a 76-foot San Lorenzo.
Yes, it was.
So actually, depending on who you talk to, it's in the yachting world, not necessarily a really big boat.
Okay.
But for this client, big enough, and it was in commercial, it was charter. So he's looking at revenues and lost charters and all of that. So he agrees to come in and do this engine work and get it done in a reasonable period of time for $218 plus or minus $1,000.
Right, and the scope of work was laid out in a document that said this is going to be the scope of work.
Good, which will be very important down the road for sure. But the final invoice, that's the part that caught my attention too. The delta between that original work order and that final invoice, you're close to $100,000 variance, $312,000 out the door versus the $218. Let's go do this.
Yes.
I get it.
Yeah, and a big part of that.
Use that, and whether you want to add a zero or take a zero away from that in any financial transaction, when you see that much of a difference between what you're expecting and what you ultimately end up.
Especially when the scope of work really has not changed.
That's important.
And that's right.
Really
so, there were a few things that were brought up, and those minor things maybe can account for 10, 20% increase. But the scope of work generally stayed the same. And so, the surcharges were a huge part of this because he went to other providers to do some of the work. And so those other providers, which he contracted with, he paid directly. They did the work and he paid them additional funds in addition to this.
Sure.
And then Safe Harbor says, oh, well, we're going to tack on 10% for what you paid those people. And one of them, the people said, well, I'm not giving, they contacted the contractor and said, give me a copy of the invoice. This is all in our complaint. And they said, well, we're not going to give that to you. And so they just kind of said, okay, well, we're going to estimate what we think it might have been and surcharge that. So, that is just going too far. Client felt like this was just going too far in too many ways. And through our investigation, it appears that this is a common practice.
Well,
and so that's what we want to try to establish in this case.
Maintaining as neutral position as I can in all this, but I was privy to a couple conversations a year ago where two very large boats crossed the Atlantic on their own bottom to have work done in Europe in the Mediterranean instead of doing it here in the United States. And the comment that came back from the captain was that he felt that he was in his words, corruption corridor with very few choices as to where he could bring his boat for the kind of work that he wanted to get done. And as a U.S. yachting entity, I listen to that and I think about that and I say, wow, that's not good for anybody in our industry, because those boats going across the pond to get that work done over there means that there's man hours that didn't get billed here for people that are employed to be working on these boats. There's materials that were purchased in Europe rather than the United States. The revenue and the impact the vessel has when it's here in the United States.
Absolutely.
Crew provisioning, all of that. They're economic machines, and you don't want to push those boats across the pond. If you
Absolutely. We need to keep them here.
Right. So good business practices, good shipyard practices help ensure that happens.
Totally.
Can you talk a little bit about what's being claimed in legal terms? We've talked about in general, but when you're bringing this lawsuit, there are legal specifics that you're going to point to say this is the problem, this needs to be addressed.
Right. So the theories of recovery here are both statutory and common law. So our common law theory is what's called an unjust enrichment, basically that they're making money unfairly, and that we conferred a benefit to them. They conferred a benefit to us, but they don't match up. We gave them more money than what they gave us. So they've been unjustly enriched.
Okay.
So that's kind of the common law theory. And then the other theory is the statutory violation, which is we have a statutory violation which alleges that they have deceptive and unfair trade practices in violation of South Carolina law. And lastly, a breach of contract, which is we made an agreement based upon this scope of work, and now you're not honoring the agreement that we made.
Does that fall under the breach of good faith and fair dealing as well?
Yes, in every contract in most states, definitely in South Carolina, definitely in Florida, there is an implied covenant of good faith and fair dealing. So that you make a contract, we don't have to put in there, we're going to act fairly with each other. We're not going to lie to each other. So all those things are kind of implied into every agreement. The law presumes that. So if you're telling me something or writing something in your agreement, we're going to presume it's in good faith and it's fair and that you're treating us fairly. So if you don't, then that is also can be dealt with as part of a breach of that agreement. You can breach the express terms and you can also breach the implied terms.
Right.
So all of those are the technical claims. And for the individual claim of our client, obviously we want money damages for what we've overpaid, what we shouldn't have had to pay. And then from a class standpoint, we want that determination to be certified that these policies and practices are uniform, that they're standard, that this is what they do as a business practice, and therefore all the people that are similarly situated will be entitled to similar relief. And then as well as a practice change, we want them to change the way they're doing things going forward.
Wow. So in the concept that upwards of 60 to 100,000 people listen to this podcast, in this industry, there's a lot of people that have probably done business at Safe Harbors that are now a little bit interested in what comes out of this.
Absolutely, because they're what's called a putative class member.
Right.
That's a class member that's covered by the definition. So somebody who's been overcharged, deceptively charged on their yacht or vessel repair, both in South Carolina and nationally in any of the other Safe Harbor locations, technically could have a claim under our class action if it is certified.
Okay.
So, and like I indicated, we may be expanding to some other states as well. We have another number of people we've spoken to that may be joining either our South Carolina lawsuit or we may file in other jurisdictions. We haven't determined that yet.
Okay. So right now, the South Carolina lawsuit is for this particular entity, anybody that's in South Carolina that may have done business in that particular marina?
Actually, the lawsuit right now is for our client individually. Until it gets certified, until a court says that it can be cover everybody. It's just that individual. However, because we've asked for that, there are protections and there are like extensions of certain time limitations, things that can apply while the case is pending and while that determination hasn't yet been made. So technically, yes, I mean, anybody that is under our definition could have potential rights under our suit anywhere at any safe harbor location.
So what's going on right now is the certification for this to be a class action.
It hasn't, that part hasn't even started. Like I said, we just filed the lawsuit last month. So whether or not it will stay the way it's on the course, but that is the next logical step. We start doing the case, we get into the pleadings, and then at some point in time, once we've done some initial discovery, we file a motion for certification of the class. But those are steps down the road.
Okay, so timeline, what's that look like? Are we talking years and years or months and months? Or?
Actually, not years and years. You know, most courts, especially in federal court where we are, they can litigate these cases within a couple of years. You know, they're depending on whether there is certification or there isn't certification, there can be appeals that happen in the course of the case. That does add time.
You would expect.
So, yes, I had one of my bank cases where we had certification. It was not appealed. After the certification, it settled, but that case still took over 3 years. So it takes a long time. And, you know, one of our other class action cases that did get appealed after it settled, one of the class members objected to the settlement, and so that took a long time. So there's a big process that goes with the class. But generally, I would say about 2 years to see whether or not you get a class certified and if that stands. That's just a general ballpark figure.
Not surprising.
No.
Not surprising.
The wheels of justice don't always move swiftly.
But
That's
they
for
move.
sure.
They're a constant motion. What's the implications for the yachting industry as a whole in this? Is this a cautionary tale? Is this the genesis of similar type of actions? Or what do you see from your perspective? Because you're not really in the yachting industry, but you're well placed in the legal field that looks at things like this.
What I've seen in the past in cases is that there's change from both the customer consumer side as well as the industry side. So lawsuits, class action lawsuits, they get the attention of both. So consumers will be like, well, wait a minute, maybe I don't have to do this, or maybe I can ask more questions. Maybe I need to do more things on my own to become a more educated consumer. And then also, hey, and if I don't like the way things were done, I should do something about it.
Right.
And that also can affect change. And then from the industry side of things, they look at things better and say, hey, you know, we don't want to be known as this kind of business, or we don't want to do business that way. We want to distinguish ourselves as a business that doesn't do business that way. Let's look at our contracts. Do we need to clarify things better? Do we need to have more clarity in our paperwork? Do we need to let our customers know more upfront what they're dealing with? So yes, I think there is a change that can happen, and I've seen it happen in other industries, and I would hope that for the yachting industry, marinas, anybody that does business with a vessel, from whether it's a repair, a cleaning service, whatever it is you're doing for a vessel, storing it, all of those things, that you have more clarity with your customer and make sure that what you're doing is fair and that you're not taking advantage of them because they have no other choice, or because they've already committed to something, or because you're not going to let them have their boat. You're not going to let them splash unless they do something. So all those things you need to always constantly look at as a business.
I think the cautionary tale here, too, is to take the extra time to read your contracts.
Absolutely. And I always tell people that all the time. It's interesting, the more and more I've learned, now that we've become very electronic, it's time. There are times where the contracts aren't even presented to somebody. They give them an iPad, or they give them something where they're just like flip through like this and they say, sign here.
Yeah, right.
And so and then later they'll say, oh, I'll email it to you later. And they never do.
Right.
So a lot of times you got to be really careful that someone is like flipping through and they'll tell you, oh, this is just our paperwork. And so you don't even really know what you're signing. So it's become a real issue in a lot of situations where it's not like it used to be, where like you're holding a piece of paper and they say, oh, can I have a copy of that? Or they'll give it to you in triplicate. That doesn't happen anymore. No. So, more and more consumers are signing things that they have no idea what they're signing. And it's done in a way that they can't take the time to sit there, oh, well, where's the paper? Or they'll give them a front sheet and there's all this stuff on the back. They never see the back.
Or you get 30 pages in number 4 font, and who reads all of that?
Yeah,
It's like
tiny
the
print.
last time you bought an iPhone or
Right.
an electronic device, and you have to agree. And if you don't agree, you don't have use of the. Yeah, that's
It's very true.
Right.
And like another example is you want to go on a cruise, and you got to click here, I accept terms and conditions, and there isn't even anything there. You have to like go to a different page on the website to then go find their terms and conditions, and they're not there. And then they say, oh, well, here's all the terms and conditions. Well, I didn't even know where those were. So they're changing, again, there's ways now where they have to hyperlink it, where they have to give it to you right there where you're checking it. But you know how those changes were made? Through lawyers that filed lawsuits that said that's not fair.
there you go.
So that's how we affect change. And unless somebody forces them to make a change, why would they? Why should they?
You're exactly true.
So unless you're like a lot of companies, hey, we're going to do it the right way.
Right.
Great, I applaud you. But the ones that don't, we need people to force that change.
I like it.
Yeah.
Well, Cristina, we're going to keep following this case. I think
Okay.
in our industry, it's important that we pay attention to these
Great.
things. We look at the transparency of our transactions and the way we conduct business with each other.
Absolutely.
The yachting industry, I think, is an amazing industry. It's constantly evolving as a professional entity. I mean, when I got into it over 40 years ago, it was truly a cottage industry, and it's grown up a lot in the last couple of decades. And I see a propensity for getting better for across the board for all sectors of our industry. I think we're all looking to do things at the highest level we can.
Good.
Our clients are at the highest level that you can imagine, and they're expecting excellence and exceptionality from us. So hopefully this is going to be something that resets the paradigm for how things are done in shipyards. We'll pay attention to how we treat our
Terrific.
clients.
Yes.
And, something out of this situation perhaps will create some improvement.
I hope so.
Yeah.
I always strive for that. And litigation in general brings about change. And so I appreciate you putting this in the highlight here and giving us some attention and time, and look forward to continuing to talk to you as the case develops.
Well, it's my pleasure, Cristina. Thanks for having us, and thanks for joining us.
Absolutely, my pleasure.
We'll follow up in the future with you.
Okay, thank
All
you.
right. And until the next time, I'm out of here.